My name's David Henson. I'm a partner with Henson First Attorney's offices. We have offices throughout the state of North Carolina, and we specialize in personal injury, workers' compensation, disability claims, condemnation when the government's taken land to build roadways, and last but not least, medical malpractice and medical negligence claims. So my job today is to talk to you about legal claims against EMS and medical providers, how to maybe a little bit of education on what the current status of all of that is in North Carolina. How do we help kind of keep you out of trouble or out of having any of those issues, and hopefully allaying your fears a little bit, but also hopefully tugging at your chain just a tad to remind you of some of the risks out there. But to give you a little bit of background, prior to becoming a lawyer, I worked with South Orange Rescue Squad and Carolina Air Care for a number of years. I basically paid my way through college and law school with those. So I've sat in the seats that you guys are sitting in today. I understand the stresses and the pressures that you have when you're taking care of patients and in the difficult circumstances in which you do it. Now, we're on the opposite side of the coin, however, and we make claims against medical providers when they fail to deliver the standard of care that's expected of those providers in the state of North Carolina. So I think I'm pretty well situated to evaluate and see both sides of the coin. Now, I just kind of want to start with what some of the current thinking and thoughts and what news tells you about the status of medical negligence and malpractice lawsuits in North Carolina are. So, you don't have to watch TV for very long and you see that folks are talking about how the number of medical malpractice cases are skyrocketing, that there are all these frivolous lawsuits, that verdicts are out of control and they're just exploding all over the state and the country. Right, everybody's heard that before, right? So let's look at what the current facts are regarding the state of medical malpractice and negligence cases in North Carolina. So in our state, there are about 250,000 civil lawsuits filed every year. So that includes all civil things. So car wrecks, divorces, businesses fighting back and forth, disputes with your neighbor, medical malpractice cases, about 250,000 across the state. Of those, about 300 annually are medical negligence cases. So questioning the care that's delivered in the state of North Carolina. That's across all medical providers, hospitals, nursing homes, care clinics, EMS systems, dentists, psychologists, anything that is kind of medical in nature or orientation. Over the last 10 years, we've seen about a 70% drop in the number of malpractice claims that have been filed in the court system. There have been a number of changes which have drastically reduced these numbers, and the intent is to help protect medical providers from some of these cases. Of those that are filed, about 96%, so the vast majority of them, are resolved at some point in the court process. Only about 4%, so we're talking about 12 cases a year, generally go to trial across all hundreds counties and across all of the hundreds of thousands of medical transactions that occur on an annual basis across our state. Then of those 12 that on average go to trial, the median award is about $300,000. Does that surprise you guys, either in numbers or dollar amounts? Would you have thought it had been more or less? What would you guys have thought? Frankly, I would have thought more money. I'm a lawyer and I'm in it, and I didn't realize the number until you really start digging into some of the data. So we see that some of the facts really don't match what is told to us in the public media and whatnot. So what are some of the most common claims against EMS providers? By far, it would be emergency vehicle collisions, which really is not a medical negligence or medical malpractice case. It's just a straight up car wreck case or personal injury claim in reality. So sometimes we see cases where two ambulances hit one another. We're very familiar with one of those cases, but more often than not, it may be driving through emergency traffic and an ambulance having a collision with another car. That doesn't always mean it's the ambulance's fault. We've all driven Emergency vehicles, you know how other cars sometimes react, and more often than not it's because they're not paying attention and not moving out of the way and we're doing what they're supposed to do. But it's still lurking out there as those are the bulk of the claims. Then we have dropping and improper handling of patients. We've seen some of those numbers actually go down in recent years as agencies have switched over to different types of stretchers with the hydraulic stretchers and things like that. Although, I've heard in a lot of the mountain counties that some of you guys don't really like those hydraulic stretchers necessarily because of some of the challenging terrain that we have and weight and various other factors. But kind of across the board, the folks in the flatter counties tend to like them a little better, it seems like. But we do see stats dropping in some of those negligence claims when they are implemented because the risk during those transfers and loading and unloading and things like that are less. And then the next bulk of cases we see are medical negligence, where it's medication errors or improper procedures or folks doing things outside of their license, not following protocols, those types of things. And last of all, the big category would be consent and refusal of care issues. We're going to spend a lot of time tonight talking about medical negligence and consent or refusal of care. Does any of that surprise you guys? What you would have expected? Okay. So this is the definition in North Carolina of medical negligence. So I'll let you guys read it. And then what we're going to do is break it into the legal parts that as a lawyer, how we categorize and think about these things. And when somebody calls me and says, hey, I think there was a medical malpractice claim committed against myself or a loved one, this is the rubric which we start thinking, which is duty, breach, causation, and damage. So let's look at the first category, which is the duty of care. When does that duty start between the provider and the patient? And so, we've got let's say the scenario of a motor vehicle wreck. There are 4 people inside of the vehicle, and we've got one who is very significantly injured and needs relatively immediate transport. And then we've got, let's say, an elderly person who's sitting on the ground that says, hey, will you just help me get up off the ground? And you reach your hand out, pull them up off the ground, and then from that point forward, they say, I'm doing great, thank you very much. So between those two, how many patients and how many ACRs or PCRs do we need for those folks? I'm sorry? I wouldn't get one on the person I held up. Okay, so in a lot of counties, that's what we hear is folks say, look, I would only do one ACR on that because only the one person's going to get transported. The other one, all I did was help them up off the ground and didn't really do an assessment and any treatment for them.
They didn't call 911. They didn't ask for your help. In Henson County, we've got a section in our refusal form. The second part of it says you did not initiate 911, you did not call for service, but still a refusal of care. And that's what we use on motor vehicle collisions. We don't use them in every case, but that way we get everyone in the car to document that they didn't want it.
Okay, and I think that was traditionally the trend over the last 20, 30 years, certainly was when I worked EMS. I think most agencies are rethinking that. My understanding generally is your agencies in the 4 counties that we cover have basically rethought that, and the prevailing wisdom right now is you need ACRs on all those folks. By touching that patient and helping them up off the ground, that has now triggered the duty of care, and they need an ACR and a refusal to accompany with it if you can get it. I realize that creates extra work for you guys. I realize that can be a pain in the neck to have to go get that, particularly if you got 4 people in the car. But in reality, I think the way most folks and legal systems are looking at that is, even by sizing them up, talking to folks, hey, are you okay? Are you okay? Are you okay? You're in essence doing an assessment there, and you have established that duty of care irregardless of whether they called or not. And so my general understanding from most of the administrative folks that we've talked to in the other counties is they would want ACRs done in all of those, for all of those people. We're right on that, Ned?
Here you've got the 3 other county county-owned agencies represented.
Okay.
Only one person from the mission aid.
Okay, so I'm not going to answer the question for what your county or agency or protocols would be, from a legal standpoint, it would be my very strong encouragement for agencies. In fact, I've had this conversation with a whole lot of counties now across the state that I personally think that if you help that elderly person up off the ground, I think you've now established a duty and you got to finish it out.
Can I ask a question?
Yes, sir.
What if we're talking about someone who slid out of the bed in the middle of the night and is called for a citizen assist to a standing position? Is your recommendation some type of paperwork on that as well?
So the question, just for kind of the video purposes, is, let's take it out of the context of an MVA. Let's put it in the context of a patient falls out of bed, something like that. They call for assistance to get up. In my opinion, as a lawyer, I would say absolutely they need an ACR on that, because in essence, while you're there, you're doing an assessment on them, right? I realize that you have only asked for help, but you are doing a mental assessment. Are they okay? Do they seem to be bleeding? Are they breathing? You're doing all those mental things, and I personally think that triggers your duty of care. And I would be very reluctant to not do that if I was in your shoes providing care. Because what we worry about, and we're going to talk about one of these cases where there was an improper refusal with a patient, and we had a bad outcome with that patient. So the lightning doesn't strike very often, but when it does, it can be bad. So that patient you help up off the floor, what do you do when they have a brain bleed? You leave, and 2 hours later they're dead in the bed. What agency is going to get sued?
So, and this is the question, because we're rewriting our SSDs right now. We're in the middle of revamping them and just going through them. And that's why I'm here. The refusal policy that we currently have is, we've discussed it for many, many years, and we had talked to an attorney, because we allow people less than 18 years old age to refuse.
Mm-hmm.
And because our county attorney at that time said, oh, it's fine. Only the parent can override their decision. Well, the current county attorney we have said, oh, absolutely not. A minor cannot refuse. And my whole question became, was when do they become a patient? So what you're saying is, as soon as you talk to somebody, now they are a patient.
I would say across the counties that I have talked with, and across the state, the majority have now radically changed their position, and they will, almost with maybe one exception, have all taken the position that all of the scenarios we've talked about would require an ACR be generated. And we're going to talk about minors in a lot of depth and detail in a little bit, so we'll kind of come back to this minor issue. And I feel very, very strongly about that as a lawyer, what I would urge your agency to do. And I think your current lawyer is accurate. I think your prior lawyer is way, way off base on it, in my opinion. Okay, so we have this duty of care. Let's assume we all agree that now they're a patient. And if there is a violation of that duty of care, what's the legal standard by which that conduct is determined or judged? What's the lens that the law is going to look through it at? And what the law is going to say is, what would a reasonable medical provider with similar experience and training, with same or similar community, do under the same or similar circumstances? So, does this standard require you guys to be Superwoman or Superman? Does it require you to save every life? Does it require you to make every perfect decision or anything like that? So does this standard make you feel good to some degree or bad? To me, if I was a medical provider, it would make me feel pretty good. It would make me realize, look, I'm going to be judged based on what a reasonable provider would do under those same circumstances. And the law is going to recognize that the care delivered in one county may be radically different than the care delivered in another county. If you're a paramedic in Gates County, which is very low socioeconomic, versus a paramedic in Durham or Orange or Wake County, you're talking about a very high metropolitan area, and they've got a lot more equipment, a lot more training, a lot more experience for the most part. And those two individuals in those circumstances, under the eyes of the law, what a jury would be deciding on, are going to be treated differently. And so we're going to take what is that experience and education and training of that paramedic? What types of stress are they under? If you're in a, if you're upside down in a car and it's pouring down rain and you're trying to extricate a patient, that's different than if you're providing care in an ER, right? I mean, we make different decisions. We've got different stressors. And so that specific situation is very important when we're criticizing or questioning that care that was delivered. Okay, so then the second part of the test is, was there a breach of the duty? Was there negligence? And again, we've got the exact same standard of care that we're filtering all this through to try and make a determination as to we think the component of it. But how do we prove this? I mean, from a lawyer standpoint, how do I figure out whether there was a departure from the standard of care? And so in our office, what we do is, we get a call and we think, well, this sounds pretty bad. I mean, given the facts of what the client's told us, let's dig into it deeper. And so we go out and order all of the medical records for this patient. I'm going to get 10 years worth of prior medical records before the incident. I'm going to get the ambulance call report. I'm going to get the emergency room report. I'm going to get the follow-up reports, as much medical records for as long a period of time I want to get and filter through. And in my office, it's going to get filtered by nurses first, then it'll get filtered by paralegals, and then it'll go through one or multiple lawyers up from 5 to 10 people in my office may look at a file and try and figure out, do we think there was a breach of the standard of care by that medical provider? And if after all of that analysis we think, yeah, this doesn't look good or something weird happened, we can't figure out what it was, but it sure looks like there may be a problem, then the first thing we're going to do is start contacting potential experts. And we're going to reach out to those experts and say, will you look at this file and give us an unbiased opinion of whether you think there was a violation of the standard of care? Now, the law changed a number of years ago, and what it requires is that before a lawsuit can be filed against any medical provider in North Carolina in a medical negligence case, that I have to have what's called a 9J certification. And that 9J certification means I have to get an expert to review all of those records that I just talked about and then certify in an affidavit format that they think there was a violation of the standard of care. So I can't just willy-nilly go down to the courthouse and file that lawsuit without that 9J certification. In fact, if I do it without the 9J certification, my case gets thrown out of court. And there is no way in North Carolina to fix that defect when it gets thrown out of court. Okay? So I get one bite at the apple as the lawyer. Otherwise, I'm getting sued for legal malpractice. Now, this 9J expert can't just be any old willy-nilly expert that I want to call up and pay. It's got to be somebody who actually knows and does what it is that we're questioning. So in the context of a paramedic, my expert needs to be a paramedic. And it needs to be somebody who either practices or teaches in that specialty and who does that type of procedure. So I can't get a paramedic who's never done a certain procedure that one county allows and another one doesn't. He or she's got to know what they're doing and know how to do it. And then they also have to have been clinically active within the year preceding the date of incident, with the majority of their time in clinical practice or instruction. So it can't just be an armchair quarterback who retired 5 years ago to say, yeah, that's not how we used to do it. That's a violation of the standard of care. They actually got to do it and do it recently. So this is something that should make you guys feel a little bit better, because this calls out a whole lot of cases when people can't figure out what happened. We've got to have an expert evaluate this before I can move forward. Does this make you feel better or worse? Have any of you guys ever been asked to be an expert in a case? So in my opinion and experience, I think one of the smartest things you can ever do is agree to be an expert in a case. And it doesn't matter whether it's for the plaintiff or the defendant. It really doesn't matter. Because I think what it forces you to do when you get that call and you consider doing it, it forces you to go back to all of your policies and procedures and all of your protocols and all of your training materials and all the books you got over the years and all the classes and continuing ed you ever took and really, really learn that area and relearn it. And I bet what you're going to find is there's going to be more technical stuff in there that you've forgotten over the years or forgotten while you're doing it. God, I didn't realize that the protocols had not 10 steps rather than 9. I'd forgotten about one of those. And so invariably what it forces folks to really do is evaluate it. And in essence, what you are then doing is helping a lawyer and the legal system figure out whether there was something that went awry here. And again, we're not asking for Superman or Superwoman, right? We're asking for, was there a pretty significant deviation from what a reasonable person, a reasonable medical provider would have done in this circumstance, right? And so you can be very helpful in either working to make sure that provider claims aren't brought against them, or if you sit back and think, wow, they really blew it, this is just god-awful terrible, then it also allows that injured party or those patients to be able to move forward and seek the compensation that the legal system allows them to do. So I always encourage folks to think about doing it. It will force you, and I think you will end up learning more than you thought you knew. Yes, sir. Right.
That attorney's out again, and that plaintiff finds another
No.
attorney, that ends the plaintiff.
If the lawyer blows the non-J certification, the case is dead. There's no way to fix it in North Carolina. And lawyers get sued all the time over this non-J certification. They get nailed all the time. And so, what I found is, first of all, that non-J rule cuts out a whole lot of frivolous cases. I mean, it does what it was supposed to do. It calls out some of those cases that might have gotten filed 20 or 30 years ago. The second thing it does is it effectively forces out if some of those lawyers that really should never be filing those cases to begin with. Some lawyer who does criminal work and has no idea how to handle a malpractice case that wanders in the door and he or she decides to file that case when that's not their area of expertise or training. And so, sometimes folks screw it up and then they end up invariably getting sued by those families. And they should. I mean, if they mess it up, they got to be held responsible for it. So the third component of medical negligence is causation. So we've got the duty, we've got the breach, now the lawyer has got to prove causation. And this is the nexus between the negligence and the injury. And if I can't prove where the links of the chain all connect together, then I don't move forward in my case. And as medical providers, including myself, we all probably have had cases where you do everything right and you have a bad outcome, right? Some people are going to die no matter what you do. And then if we're honest with ourselves, some of us have had cases where we maybe didn't do everything right, but there was no harm, no foul, and the patient ended up okay, right? And so the question is, I've got to be able to show that whatever that breach of the standard of care was, it's got to connect to some injury. And if there isn't that connection, there's no case. And cases people lose on this prong of their burden of proof all the time. And usually if somebody loses, this is the prong that they are losing in court on for an injured person or a wrongful death claim in a malpractice case. Any questions about that so far? Okay, so then the fourth thing that has to be proved are damages. So you can have a breach of the duty or the breach and then the causation, but if there are no damages, if you do everything wrong but there's no harm, no foul, there's no case. No matter how bad you screwed up, if there's no injury to the patient or no damage, no case. So you've got to be able to show this component. There are two types of damages that are out there. So we've got compensatory and punitive. Compensatory compensates people for what they've been through. Punitive punishes or deters future or prior conduct. So let's talk about the compensatory component. There are two parts. So the first is economic. This is anything that has a dollar tag attached to it. The cost of medical bills to fix the problem. The cost of medical bills into the future to take care of this person because of the negligence that occurred to them. Their lost wages or their diminished lost wages. Let's say you had a $50,000 a year job and now you can only hold down a $20,000 a year job. Well, that person has a $30,000 difference that can be extrapolated out. Let's say it's a permanent injury, that they're going to be able to go back to their same employment, then that could be extrapolated out. So these compensatory damages, there's no limit on them. I mean, whatever those things are. So in a case where negligence occurs and somebody is rendered a quadriplegic because of that negligence, and I can prove all those elements, you could have economic damages of $5, $6, $7, $8 million in a case like that. And we get life care plans on a pretty regular basis where that's the case, if it's a catastrophic injury. So then we have non-economic damages. And those are the things where reasonable people can disagree on the dollar amount. So these are the squishy kind of things that like pain and suffering, emotional distress, loss of enjoyment, me not being able to pick up my child, you not being able to play with your grandchild, basketball, me not being able to be a very good spouse because now I'm a paraplegic rather than being able to help out and do all the things around the house that I used to be able to do. It's those things that you may think aren't worth very much, I may think are worth a lot. And the jury's just got to decide, what do they think all this squishy stuff is worth? In North Carolina, those non-economic things are generally capped at $500,000. There's some exceptions to that, but the intent of this by our legislature was to try and limit the verdicts and the judgments against medical providers to keep these judgments lower. And I think that's why you saw that average verdict at $300,000 in the last 12 months. That's in part because of this cap that's holding some of these back. Okay, so then we also have our punitive damages. So this is to deter bad conduct. It is somebody has fraudulently messed with the medical records to change them later on to try and see why or change what really happened. It can be, the ambulance was being driven 75 miles an hour in a 25 mile an hour zone. It can also be a paramedic comes to work under the influence, so they're drunk when they come to work. Or a paramedic gets hooked on opioids and they are providing care when they're under the influence of opioids. Punitive damages then can have $250,000 or 3 times the compensatory damages can be lopped on top of it in a case. So let's take the case where we've got a paramedic who has an opioid dependency. Their partner doesn't tell on them. They don't disclose to themselves. Supervisors don't rat out on them, or not rat out, but don't disclose it to anybody else. That paramedic gets in the truck and is responding to a call down here in Asheville, and in a 25 mile an hour zone is going 55 mile an hour and runs over a child. And that child is rendered a quadriplegic. It's not a very fantastical set of circumstances that we could draw. It happens all the time. So in that case, let's assume this very seriously injured child has an $8 million life care plan. He's catastrophically injured. He's going to need to take care of for the rest of his life. Well, because of that punitive aspect, because of the excessive speeding, and because of that opioid interfering with the ability to drive or render care, well, now we got 3 times that. So we got potentially $24 million on top of the $8 million that could be lopped on top of this case. That all of a sudden, you and your agency have dug yourselves into a very, very deep hole. And so these punitive damages are designed to really have a bite, to deter bad conduct. This stuff is scary, and it should be scary. And that's why, particularly in today's world, when we have an opioid epidemic, it's not just the public. Opioids are, there's a huge amount of risk and potential for abuse in our own systems, particularly when folks have access to them. Yes, ma'am.
So, if you have a partner that has a drug problem, an alcohol problem, even a health problem that's not being addressed properly, and they show up to work day after day, and you have little incidents that have not caused a problem, but you foresee something in the future, you can be held as liable as that person.
So the question is, let's assume you have a partner or a coworker who has some of these issues. They may have a drug or alcohol dependency issue or mental health issue that is prohibiting and is impacting in their day-to-day care, working only minimally in most cases, but you see that impact and you don't say anything. What kind of liability could a practitioner have? And I think in that particular context, if the bad stuff hits the fan, your agency has a tremendous problem. Because not only, should the coworkers have reported it up the chain of command, but you've got the administration that should have dealt with this issue, and now we're really exposed in this punitive damages issue. So I think the reality is you absolutely have to notify the agency, run it up the chain of command, and hope that issue gets dealt with appropriately. And my understanding is, kind of the state EMS director and other agencies are really circling the wagons on this issue, particularly with the opioid epidemic, and trying to lock down how they are handling the management of narcotic medications and those types of things. But even if they're not stealing out of the drug box, if they're getting it from home or somewhere else, absolutely, I think you have a duty to disclose that, or otherwise your agency could really find themselves in some deep, deep water.
I think just to add on to that, if that person can be
So just for the purpose of the video, the comment was that when we have early intervention with coworkers that have mental health or substance abuse issues or just life issues, early intervention can usually prevent all of those future things. And usually, once they get help and treatment, the assistance that they need, they integrate back into the system and go back to their old jobs. But I think we have a moral obligation for our agency, but also for the public we serve to alert those folks and the agents and the higher ups when you are identifying those problems. And I know it is a very hard thing to do, but we owe it to the folks that you serve in your community. So we had that duty, the breach, causation, and damage. Okay, so now as the lawyer, I'll look at it. I think I've got the 4 elements of being able to move forward in my case. What level of proof do I have to meet? So the first standard that most people are familiar with is beyond a reasonable doubt. So beyond a reasonable doubt basically in the law means if a jury has any doubt that the person committed this crime, then you can't find them guilty. The old, if the glove doesn't fit, you must acquit. OJ got off because of beyond a reasonable doubt. Some people on the jury felt like they had some doubt whether or not he did it. And because the law is that strict, you can't convict in that situation. That's not what we have in medical negligence. In North Carolina, we have the standard of preponderance of the evidence, which basically means, more likely than not, 51%. 50 and a feather is what a lot of folks will call it. And my burden in making a case, all I have to be able to show is 50 plus a little bit. Now, all the other side has to prove is 50 and a little bit too. So that's the fight in most cases. Now, our legislature a few years ago, with the intent of protecting medical care providers, particularly in emergency medical decisions, they changed the standard to what's called clear and convincing evidence for those types of cases. Now, most folks in the legal system, lawyers, judges, there really is no clear definition of what clear and convincing means, and the jury is not really told what it means. So often, I don't think, frankly, our court system and our jurors truly understand what that burden means. Is it 60%, 70%, 80%, 90%? It beats me. Similarly, there was no real definition of what emergency medical decisions is. It's not really been litigated in the court system. It's not real clear. You make decisions when you're upside down the car, it's pouring down rain in the middle of the night, you extricate the patient, you do something that, it causes injury, it's outside what a reasonable paramedic or EMT would have done. I think that falls within emergency medical decisions in that context. Now, conversely, if you're transporting a patient and loading them into the back of a truck, is that an emergency medical decision? And you drop them? I would argue no. I don't think that's emergency medical in the context of the way the legislature intended it. Now, different people are going to fight about what they think defines an emergency medical decision, but the way I read the statute, I think it's interpreted as when you're having to make snap decisions under a whole lot of pressure. And I'm not totally convinced that transferring a patient on a stretcher is that. At the end of the day, though, a judge has to instruct the jury as to which one of these burden standards go with that case when they're trying to make a decision. Okay? So then there are some other negligence claims that are lurking out there. One is called negligence per se, which is when negligence occurs and it directly violates a statute in North Carolina. And so when it violates a statute, you automatically get negligence in the case. Then we also have res ipsa loquitur, which in Latin basically means the action speaks for itself. So this would be, in a lot of cases, like a retained sponge case, or a scalpel left behind, or a case we looked at recently where a drill bit was left behind after a knee surgery, and the orthopod didn't notice that the drill bit was gone, first of all, and second of all, didn't ever look at the x-rays afterwards when he was trying to figure out the positioning of what he had done to see that there was a drill bit still in there. So that type of case would fit into res ipsa loquitur, that you're not supposed to leave a sponge behind. And so the court kind of lets you jump ahead on some of that, and you don't have to go through all those hoops necessarily trying to prove that you don't leave a sponge behind. Doesn't really apply in an EMS context necessarily. Or you really have to struggle to find one that would fit into that, but these are claims that are out there that we want to talk about. So next of all, what are the time limitations? How long can a case sit out there before it comes back and bites you from the behind? So every case in North Carolina is governed by a statute of limitations, which is the time period in which a case has to either be settled or a lawsuit filed. So in North Carolina, for a personal injury case, it's 3 years. For a wrongful death case, it's 2 years. If they wait outside of that period of time, they're out of luck. If the lawyer has the case during that period of time and blows it, the lawyer gets sued. Lawyers get sued all the time on blowing statute of limitations. There are some exceptions to it. There's for continuity of care. Let's say you've got a practitioner that is ordering regular chest X-rays for one of their patients, and they miss every single time that there's spot on the lung indicating potential lung cancer. Let's say, and they do this repeatedly over the course of a year. Then the law is going to look at the most recent act as where you start calculating that statute of limitations on it. Benefits the patient in that context. There's also a discovery rule. So let's say you had that retained sponge case, and it took some period of time for the body to start rejecting it for whatever reason. Then the law could allow you to tack on some additional time because you had no reason to suspect or to know that that was in there causing those problems until a certain point. And then for kids, we kind of have this calculation that has to get done depending on whether they're over 10 or under 10 on how that statute of limitations is calculated. So how are most cases resolved? In North Carolina, every civil case has to go through what's called a mediated settlement conference, or mediation. Anybody ever been through a mediation? Anybody ever been divorced? You've probably been through a mediation, or any other type of civil dispute or claim. And mediation, basically what happens is the lawyers and the parties sit down in a conference room, each on one side of the table, and then there is a mediator who's either a lawyer or a retired judge, and the mediator's job is to go back and forth between the two sides, trying to see if some sort of resolution can be worked between the two of them. About 2/3 of cases settle at or around mediation in North Carolina. So it's a very effective tool for clearing out a large number of cases out of the court docket and out of the system and getting them resolved. Now, then cases when they don't settle at mediation, everybody would notify the court, and then you would proceed forward to trial. And in trial, the case goes before a jury, and the jury verdict must be unanimous. They can't majority rule on it. All 12 people have to agree on whether there was negligence and what those damages are. And in today's world, getting 12 people to agree on anything is very, very difficult, right? You don't have to watch TV for very long or the news to see that. But that's the problem sitting out there. If the jury can't agree, then there's a mistrial and you start all over. And you go again until you get that unanimous verdict. Now, some cases are plucked out of the court system and instead end up in arbitration. And arbitration is where 1 or 3 arbitrators, lawyers or retired judges, will decide the fate of a case rather than a jury. Now, in the medical context, the rules for arbitration are very much slanted against patients. It is not a very fair forum for patients to be in. And so, as a lawyer, I generally recommend that, if you see an arbitration provision for you or one of your loved ones when you're checking into a hospital or checking into a nursing home or assisted living facility, I recommend getting your pen out, scratching through it, putting your initials, and now you have all of your full legal rights rather than them stripping them out without you having any earthly idea what you're signing when you're checking into the emergency room. Either way, this is how cases will ultimately get resolved. Now, I know you guys, most of the agencies, is everybody from different agencies, do you all have digital records now rather than handwritten? Everybody, yeah? Okay, so let's talk about locking of records, though. Does anybody's agency allow, once the record is locked by the paramedic, can the service provider unlock it and make changes later on? Some counties allow that, some don't.
You have to get the supervisor's approval.
Okay.
And it has to be in a form, you have to formally write an email, so there's record of what you want to.
Okay. Great, so that's the next step. Some counties allow the paramedic or provider to unlock and make edits or changes. I generally very much dissuade that type of power or ability. The next step would then be allowing a supervisor or administrator to unlock and make those changes as would be requested. The general trend that I have found across most counties is that generally folks are moving away from allowing that because it causes potentially a whole host of problems. And that is, when something bad happens, there is an innate temptation to go back and CYA and start making changes to the records. And what happens when a lawyer or the folks involved in a case start suspecting changes to the records, we're going to do a couple of things. First of all, once I file my lawsuit, I'm going to go put a motion on in front of the judge and say, Judge, I want access to the computer database. And I'm going to send a forensic engineer in there, and they are going to comb through that database and find every single change in the database, and it invariably is not going to look good for the medical provider because it looks like they're changing stuff to cover themselves. And so my general advice or preference is that an agency basically, once it's locked, it's locked. And if you need to make a change, you do it in the form of an addendum or a supplement. Because then you've got this clear kind of chronology of what happened and why. If you mess up a patient's name or you mess up a BP reading, or maybe you look at the strip and some of the readings are wrong, then you can always go back in and do that addendum or supplement and clarify it that way, rather than unlocking that file. And now we've got these weird digital footprints where you're deleting things and it looks like you're not being very forthcoming or trying to cover things up. I just think, what we want medical providers to have is clean hands, so they can say, look, the records are the records are the records, and they haven't been altered. Or if an addendum was done, here's why and here's how it was done. I realize that's an agency by agency decision, but again, the trend I've seen is that more and more folks are just simply not going to allow that unlocking. There's some question, I think, out there about when you've got billing issues, that maybe that affects billing codes and things like that. Maybe not in that context. I think that's a separate discussion, but these are things that we want you thinking about. This is just a record they actually took from a nursing home case that we were looking at. And I've just got in the part where they're doing the assessment of the patient from 12 a.m. to 7 a.m. and they're doing assessments, and they actually had blood pressure readings and pulse rates and things like that down below this. The problem in this case is the patient died at 12:30, and they were carted out around 12:30ish by the funeral home. So, but they continue doing assessments, and they have blood pressures and pulse rates and assessments on somebody who's not alive anymore. Who's not even there. So how does this look? How do you ever explain this away or unring this bell as a medical provider? There is no way to do it. You've either got somebody who intentionally was falsifying records, or somebody who was going in at the end of his or her shift and just going through the stacks of records and filling stuff out in order to check all the boxes and make sure everything's been done without telling the truth and just making numbers up. There's just no way you can ever explain it away. This case resolved for a significant premium because of this falsification. And we see falsifications in records all the time, particularly in nursing home and assisted living types of facilities where they still use handwritten records. The temptation is just too great. And once we get in and start getting handwriting experts and look at the original records, we invariably find out about it. So, why? Is it a bad idea? First of all, it's illegal. It's going to help the case against the medical provider. It really makes juries mad, and you're never going to recover from it in defending your case. It kicks my client case into punitive damages, so now I've got 3 times the damages that I was going for before. And most importantly, and problematically, is most insurance policies do not cover punitive damages. So now your agency, your hospital, your personal assets are now in play. Scary stuff. So let's talk for just a minute about insurance. So the default position for any governmental entity, whether it's a city or a town or state or the federal government, is that agencies have what's called sovereign immunity, which means you can't sue the government if they commit negligence or wrong against you. And in lots of contexts, you can be run over by a federal truck and cause serious injury to you. And guess what the federal government is going to say? Too bad, so sad, can't sue the government. And so agencies oftentimes will decide to waive this governmental immunity and go by liability insurance to protect not only their employees, but also to protect the general public that they serve. Now, my general advice is whether or not your agency has immunity or doesn't have immunity or has a huge amount of insurance or no, wherever they are in that spectrum, I still urge paramedics and providers to seriously consider getting their own individual liability policies for a whole host of reasons. First and foremost, because there are times when you can become at odds with your agency like that. And we're getting ready to talk about one of those cases in a few minutes where a paramedic got wedged away from his agency and now he's sitting there holding the bag while his agency's out of it. And it can be very problematic. And as I said, now your personal assets are tied into all of this. So, just as an example, I went out to try and figure out how much malpractice coverage might be for a paramedic. And I just Googled, I don't have any interest in this company or any of the other companies, I just was curious, and put in paramedic malpractice coverage policies. And for $1 million worth of coverage per incident, $3 million per year, the policy premium is $179. So $179, you can sleep well at night and know that no matter what happens, you have significant amount of protection for yourself and your family. For EMT volunteers, it's as cheap as like $86. So it generally runs, $90 to $180, somewhere around there. In my opinion, that's the smartest money you could think about spending. So let's talk about an example of where this was an issue and how all these things we've been talking about with malpractice and consent can come back to bite you. Anybody heard about the Atlas Fraley case? Okay, so Atlas was a good-looking young man. He was a 17-year-old football player at Chapel Hill High, and he left practice one day, comes home, and was having significant cramping. And so he picked up the phone and called 911 and asked for an IV to help fix his cramps. At the time, Orange County was using paramedic chase trucks. So a paramedic goes out in the chase truck and sees Atlas. The paramedic is James Griffin. And basically he documents the patient's having cramps in his arms, legs, and abdomen, is trying to concentrate on working the cramps out, was continuously walking around the house, wouldn't stand still for more than a few seconds, wouldn't sit down at all. For vital signs, he could only get a blood pressure standing, skin is warm and dry, a heart rate of 92, no loss of consciousness, no chest pain, no shortness of breath, no JVD, tracheal deviation, no ECG done due to sitting and standing, can't do it for any length of time. And so the paramedic then advises, be worried about dehydration and cramps, stay hydrated while playing, and keep doing what you were doing, which is drinking water and Gatorade. The paramedic then tries to call his parents, lists their phone numbers. That was good, I guess. Can't reach them, and then instructs the patient to hydrate well during practice. And then he allows a declination. Atlas signs the declination, paramedic leaves. This goes to our 16 and 17-year-olds, right? What happens to Atlas, y'all? He died. Very short period of time thereafter. So, now, just in the interest of full disclosure, I had nothing to do with this case. Not anything I was involved with. All of these materials are widely available on the web. I just simply did a quick Google search. I pulled all these documents down. I got a whole lot of friends at Orange County EMS. That's where I worked. And so, I had nothing to do with this case. It's just stuff I pulled off the internet for teaching purposes. Orange County does their investigation very, very quickly into all of this, and they find that he failed to take vital signs while both sitting and standing, should have taken temperature, should have treated him for hypothermia, should have told him to see a doctor, should have sought a doctor, the medical director's opinion, should have gotten up with his parents, and improper consent. They immediately terminate him, and what would you guess happens next? Atlas Fraley's family then files suit, and they sue Orange County EMS, Orange County, and James Griffin. The lawyer that filed the lawsuit alleged 13 violations of EMS protocols in Orange County and also improper refusal for treatment. This is the courthouse in Hillsborough where the lawsuit was filed with that 9J certification. All that stuff went together. That's where it's filed. So the case goes in front of the judge, and the judge in Orange County ends up letting Orange County EMS and Orange County out of the lawsuit because of sovereign immunity. So that leaves James Griffin all by himself. The parties don't like that very much, and so the case gets appealed to the North Carolina Court of Appeals in downtown Raleigh. So it goes in front of 3 judges in this appellate court, and in 2011, the Court of Appeals held that James Griffin rightfully stayed in the case individually because his position was not created by state law, because he wasn't a public official, and because he violated so many treatment protocols. He was so far off the reservation of what the county required him to do in this case that he just didn't do. All those 13 plus violations. So James Griffin, at this point, was probably really hoping he had spent the $179 to have his liability policy, okay? The case ultimately, more investigation was done. These are just some of the violations of the protocols that were all included in all of this. We don't know how the case was ultimately resolved. We know that it was ultimately resolved. Most cases, when they settle, are settled under a confidentiality provision. So, did Griffin pay zero? Did Griffin pay a whole bunch of personal assets? Did he have a liability policy? We have no earthly idea what ultimately happened, and I don't think anybody ever will know. But the moral of the story is, you can become unattached from your agency very quickly given the right set of circumstances. Now, Paramedic Griffin had been a paramedic for a good long while. He was not a newbie. He knew what he was doing. And, most of the other paramedics in Orange County say, look, he was a pretty good guy and he's a pretty good paramedic. He just blew it on this one. And he blew it big. So, we really want to focus on what can we do to prevent that type of stuff of happening. And so the refusal of care really was one of the biggest prongs of this case. Despite all the medical problems with the case, you just weren't going to get past the refusal of care because a 17-year-old simply cannot refuse care in the state of North Carolina. So we're going to kind of speed through some of this, but I just want to point out that for that express consent, the statute in North Carolina very explicitly requires that they have to have been explained the risks and benefits of treatment. You can't just get the consent or refusal without explaining those risks and benefits very clearly, in my opinion. So who can consent to treat in North Carolina? This is pulled straight out of the statutes. You can be a legal guardian of the person, healthcare power of attorney, living will, attorney-in-fact, their spouse, their parents or children over the age of 18, siblings over the age of 18, or the bucket list is just any individual with an established relationship with a patient acting in good faith who can reliably convey the patient's wishes. That can be a roommate, it can be a domestic partner, it can be just a friend. Anybody can basically consent if you have any connection whatsoever to the patient to get treatment. But if they're under 18, the answer is just simply no.
Does that apply to emancipated?
Great question. So we're getting ready to come to that in just a second. So, and actually before we get to that, so let's talk about in the context of where you can't find the parents. So in loco parentis. So the statute sets out that a physician, it doesn't say paramedic, it doesn't say nurse, all of those folks operate under that physician's license, so I think you guys are covered by this, but the statute says a physician may treat the minor without consent of the parent regarding a person in loco and under the circumstances of the parent can't be relocated with reasonable diligence and time is of the essence, identity of the child's unknown and treatment is urgent, where the effort to locate the parent would have a delay and the kid would get worse, or most folks don't know this last one, where the parents refuse consent, but there's insufficient time to get a court order to override them, but 2 MDs sign off on it. So you can have 2 medical doctors override a parent's or guardians to make a decision for the welfare of the child if there isn't enough time to get a court order. Anybody know that? So, this I think is very important. I mean, this opens the box of, what do we do when we have parents who are refusing care because of religious beliefs? What do we do if we have parents who have an inability to appreciate the situation and the dire circumstances of a medical condition in their child, and they say, no, we're not going to take him, even though you look at this child and you see that he is in severe respiratory distress and he's going downhill quick. The statute is in place to allow you to run things up the chain of command and get help and get that child transported. So one way to do it is with the 2 MDs signing off on it. The second way is contacting your supervisor, contacting the medical director, contacting the police, and then last of all, contacting Child Protective Services and through DSS. And I think any or all of those things would help you get to the point where you get that consent for that child. Or at the very least, what it's doing is helping you in your narrative to set out all the efforts that you made to try and provide aid for this individual. Any questions about any of that? Okay, so we now have emancipated minors. There are 3 categories and 3 categories alone for emancipated minors. First is when the child is married, which can occur at age 16 or 17 with the consent of a parent, or, God, did y'all know that kids can get married at 14 and 15 in North Carolina if a judge signs off on it? Kind of wackiness. But it's allowed. And then second of all is service in the military at age 17 or obtaining a judicial decree of emancipation from a court. If it's not one of those 3 scenarios, it's not allowed. This is the statute directly. And in my opinion, if you're providing care to that individual and they can't provide documentation of one of these 3, then I don't think you're emancipated. I think I'm sorry, you're going to have to go to the hospital. All right, so let's talk about a scenario where we have a 16-year-old mother who's single and a 2-year-old child. In scenario 1, the 16-year-old mother is having a severe medical condition and needs immediate transport. You arrive at the scene and she says, no, I'm not a-going. I refuse transport, I'm not going. What do we do? Does she fit any of these criteria? She does not. She's not emancipated. Being pregnant, having a child, does not make you an adult. She does not have capacity to refuse transport. She's got to go. And if she won't go, you got to call police, you got to call your medical director, you got to call for those 2 doctors, you call Child Protective Services, you get everybody and their brother involved and run this thing up the flagpole, because if something happens to that young girl, you're going to get sued. She's technically sued. Now, let's say the child, the 2-year-old child, though, is the one having the medical problem. And the daughter declines transport for the kid. Well, I think in that context, the mom can decline transport for the child. She's the parent. Now, I think that's a ridiculous outcome. And what would I do as a paramedic or as a lawyer or an EMT? I would start calling up the chain of command and I'd get this problem fixed. And I'd get her mama or daddy on the phone. I mean, I would not leave that scene with that child because of these interpretations of the law. I mean, it could be spun different ways, but I think the very strict application of all of this, I think we could end up with a wonky situation there. But the important factor in my mind is that 16-year-old mama for herself cannot refuse medical treatment. She's got to go to the hospital unless somebody else fits into one of those categories that can override it. Any questions on that? Okay, so there's a relatively new law also which was designed to clean up some of this informed consent stuff, which basically said there's no legal claim if a provider obtains consent within the standards of practice of the same or similar community, the same stuff we've seen all along. A reasonable person would have understood the procedures and treatments, and a reasonable person would have gotten treatment for them. So this is very broadly construed, and it's very helpful for you guys in providing care and assuming that informed consent for patients who cannot give it to you. Now, who's familiar with the STOP Act? Okay, so the North Carolina STOP Act is really an abbreviation for Strengthened Opioid Misuse Prevention Act of 2017. It was passed at the end of June 2017, and it was designed to make opioid antagonists available to a wider reach of people. So if you're a parent and you're concerned about your child being an abuser of opioids, now you can basically go to a doctor or even a pharmacy and get Narcan or naloxone to keep on your own. If you're a community clinic providing services to those folks, you can get it. As you know, law enforcement in most of your agencies now has it, and that use will expand out over time. And in a lot of ways, that's a good thing. But I do think it creates some weird legal situations that weren't fully thought out when our legislature passed this summer. And I personally think there's going to have to be a little bit of cleanup to fix some of this. But what the statute says, it's about 10 pages long, but what the statute says in relevant part for you guys is that a person who receives an antagonist that was prescribed or distributed, you guys, or a police officer, may administer that antagonist to another person if they have a good faith belief that they need it, and the person exercises reasonable care in administering the drug to the person. And then the statute goes on to say, all of these people, everybody and their brother who can get access to Narcan now, shall be immune from any civil or criminal liability for actions authorized by this section. So I think the intent here is to put this blanket of protection over everybody who could prescribe these or give these medications for folk to keep them from getting sued later on. The problem with it is, in our legislation, we don't have very many lawyers that draft stuff anymore. I mean, this is all non-lawyers for the most part. And what the statute really then says is, any person who administers an opioid antagonist pursuant to subsection D of this section. Well, remember, subsection D required the reasonable care requirement. It's not just willy-nilly, you can give them all day long. You got to exercise reasonable care. Now, I think reasonable care was designed for, a roommate giving the medication, or a friend, or a parent, or somebody like that, or a police officer. Well, you guys have a high degree of medical training, an enormously high degree of medical training. And I'm not totally convinced that you'd be held to just the reasonable care standard. I think there's an argument you might be at a higher standard, back to more of a medical-oriented standard. Now, I don't know. I'm just speculating on what the statute may or may not say. Yes, sir.
I've been thinking about this, we've been talking about it today, and I'm looking at the act right now, and as not an attorney, but my opinion is that EMS personnel or the healthcare providers aren't covered under this act. But they were already authorized to administer Narcan before this act was ever enacted. And this act, lists governmental, non-governmental organizations, local health departments, law enforcement agencies. I think it's specifically targeted at those people that maybe couldn't give Narcan.
So the comment was, on one reading of the statute, it may not even apply to EMS providers at all. And I think that may be the case. I mean, I don't know. It's brand new, nobody's fought it out or litigated it out. But I don't think we as EMS providers should just automatically sit back and say, woohoo, we're protected from all this stuff. Because I just simply don't read the statute that way. I think it requires a lot more investigation and discussion and debate about it before we just go willy-nilly and do certain things.
We get into a lot of problems, though, as volunteer fire departments, because some of them have that medical training, but, and then some of them don't get the medical training, but they're told that you administer in these situations. And you've got volunteers who show up and don't show up, and there's training records that are there or not there, so there could be a lot of issues in that case.
And here's what I'm worried about. Law enforcement gives the Narcan. Takes your truck 30 minutes to get there. So by this point, they're out of the respiratory distress, they are talking, and they refuse transport at that point. So is there a free range of debate here of whether they really have capacity? I mean, can reasonable people agree or disagree on whether somebody has capacity after they've been given this medication, particularly when God knows what else they've ingested? I mean, if it's just IV, how do we know they haven't taken a bunch of pills later on that are still affecting them, or they've got ETOH on board, or, God knows what, and as soon as you leave, now they're going to crash and die 20 minutes later?
Train the officers in here, and they get a pretty thorough, you've got to have EMS come in here and go with these people. You can't just let them go.
Right. So there's a lot of training with law enforcement that when they give naloxone, you've got to have EMS come in behind it and kind of pick up that care and make those decisions. What I'm worried about for EMS providers is, I think there's this gray area now sitting out here where, maybe you give the naloxone or maybe somebody else gives the naloxone and the patient then refuses transport, and if you allow them to sign off on it and then they tank and die, what are the odds of you getting sued later on? And now I realize we've been dealing with this for forever with diabetics, but this is an epidemic that is far surpassing diabetics, right? I mean, the numbers that you are hitting now in a metropolitan area is radically different than what you've probably done with diabetics over the years. And in my humble opinion, this problem is going to continue getting worse in the near future before it gets better. And I think at some point, somebody's going to die after an EMS provider allows them to refuse transport, and somebody's going to get sued. And I don't think you guys want to be that agency to get sued. Now, it's not going to be me making that case because I see the gray area and I see the argument, but I'm not. But somebody out there very well could take that case. Bingo. So let's go to that. So here is what. And just before we get to that, because we dovetail into that. So I pulled this from the state EMS refusal protocols, and I know you guys are more familiar with this than I am, but CRAM, of doing this capacity assessment on whether somebody has the capacity to make decisions. And this is a good reminder of, appreciating the situation and manipulating the information back and explaining it to you to really determine whether they have capacity. This is a pretty high bar to achieve, in my opinion. But what I, as a lawyer, would recommend, who used to do EMS, but a long time ago, what I would recommend, if you have that patient who adamant, by golly, I am not going to go, there's nothing you can do to convince them, there's nothing anybody else can do to convince them, and they are not going to change their mind, here's what I would do if I was writing the ACR. I'd put in everything I did, and then I would spend a lot of time citing the vital signs and full assessment after I delivered the Narcan, the mental status, and all of the competency factors, all of the CRAM factors, even if that is a paragraph or 2 paragraphs or 3 paragraphs, I'd put in the darn kitchen sink setting all that stuff out. I would put in any information that you have regarding how their method of overdose occurred. If you see track marks on their arms or their toes or their feet or wherever you see them, I'd put it in my medical records. If you see beer bottles laying around or pill bottles laying around or boxes, I'd put it in there because all of that is relevant if they tank later on, in my opinion. I would also put in every single risk and warning that I give to them. And I wouldn't put in my ACR, explain to them the risks and benefits of refusing transport. I know your agencies, almost all of them, or at least the mission ones, have a pretty good blanket refusal form. It's pretty good. But I wouldn't rely on that if it was my patient worried about them crashing later on. I would say, advise patient of possibility of relapse, permanent injury, respiratory distress, failure, death. I mean, I would put in, again, the kitchen sink rather than just risk and benefits. I would also identify all the lay witnesses who were there on scene, the police, the fire, the EMS, anybody who was there who can help corroborate that mental status and that capacity for me if something ever goes bad. And then I would put in, once I ran the chain of command up my medical control, I'd put in who I talked to on that medical decision. Again, some medical directors or agencies may not like this approach, but this is what I would do, and I would at least have this discussion with your agencies. And then last of all, I would list any responsible people who are going to be with that person when I leave. Yep.
So, especially downtown, or in general, like we are dealing with, like you mentioned earlier, people are being Narcan. Like we've seen people take off when first responders show up, and we have first responders who just got a drug and they're really excited to use it, which isn't terrible, but we're not really used to dealing with people waking up from Narcan, like we stabilize. But so like I've had issues, we've had issues where you get them up and it's lucky to get a name because they have priors and they're literally just taking off on you. And that's like one of the hardest things. Like sometimes I'm lucky, it's like if you just sign here or something. I don't know. I'm just kind of curious, like how you get good documentation.
It's reasonable medical provider, right? I mean, that's what the standard requires. So what I would do, put in as much information about the circumstances. Don't give me just one paragraph. Put in there all the details, who all was there, that police you pulled up right as you were doing it, and who the police officer was, and that they ran. I would put in excess details rather than not enough to cover you in the event that they run down the street and collapse and die, and then, a claim's made against you. Now, do I think that's the likely to happen? Probably not. But why, if it takes an extra 2 minutes to type that data in, why not? To protect yourself. It's so easy to do it. And I do the same thing in diabetic cases now. I mean, I'd basically adopt this in most of my refusals, frankly. I wouldn't always just go with that refusal form. Now, if there's clearly nothing wrong with them, would I go through all this, limit? Maybe, maybe not. If it's a simple car wreck case and, and I help the little lady up, I probably wouldn't spend 4 pages of narrative documenting it. But if I am even remotely concerned about it, or if I got Atlas Fraley, what am I going to do? You darn sure better bet I'm going to do this all day long, except Atlas can't because he's under 18, but let's assume he was 18. Now, again, I have no earthly idea what your agencies would say about that. My general experience with agencies is what you put in the narrative is your business, and they're not going to really question it. And so that's what I would do, but I would certainly have these discussions with agencies. I am in the process of having these discussions with agencies and administrators as I go to various counties, and I think folks are scrambling now to try and figure out how do we best protect ourselves in this scenario. Any other questions about that? Okay. So kind of the last part of the consent and refusal of care, I do think it's important to point out that, if you violate that refusal of care and you take them and you're not supposed to, potentially there can be claims of assault or battery or false imprisonment against you. But I ask you this question. I'm sorry? Yeah, so kidnapping's in there too. You're exactly right. But which case would you rather have? A case of false imprisonment or kidnapping where you save the person's life and they're making a claim complaining that you saved their life, or would you rather have the Atlas Fraley case? If you got to get sued on one of them, which one would you rather have? I'd rather take one of these claims against me if I got to get sued, because I'd rather walk into court and say, look, I'm sorry for saving the person's life. I didn't think they had mental capacity. They had all these problems. I did everything I could to save them. And is there a possibility you or your agency could fork over some money? Yep. But I'd sure rather have that problem of that smaller dollar amount rather than some catastrophic case like Atlas Fraley that could be millions and millions and millions of dollars in a young person. And you as an agency and you as a provider are going to have to decide which is the lesser of two evils. I can't answer that question for you. Tell you what I would do. But I think that's the analysis that you've got to make is, what if this thing goes bad? Atlas is a great example. We see all these kids now coming back from football practice and basketball practice and soccer practice, and you see in the news all the time. There was just one a couple of weeks ago where a kid came home, dropped dead, and was just gone. We're seeing these collapse cases and these young folks, females and males alike, it's not just young men, that's happening. And so, abundance of precaution. And I would err on the side of transporting and having those issues rather than not personally. So, I want to talk for just a few minutes, we're almost finished, but I want to talk for just a few minutes about customer service. And I think this is important because you guys need to remember what your public and patients are envisioning when they call 911. When I was a kid, part of what made me want to work in EMS is I watched Rescue 911. And I thought it was the coolest thing in the world. And when you watch Rescue 911, the phone call comes in, the 911 communications center is juggling all these balls and doing all these amazing things, and they get the paramedics, and the truck starts rolling out of there, and they go screaming lights and sirens, and they're only like a block and a half away, right? Because you hear like 15 seconds of sirens. And then they show up, and they do all these amazing things for the patient. They stick them in the back of the truck. They save the patient's lives, and they're heroes, right? Well, let's talk about the reality of how oftentimes EMS cases really go. And the reality is the call comes in at 3:40 in the morning, and 911 is maybe running at the same time a police shooting case and a major wreck on the interstate, and they've got another truck, and they're scrambling as best they can, and instead of that page out going out in 15 seconds, it maybe takes them 2 or 3 or 4 or 5 minutes, whatever they're juggling all those balls, right? And then you get the call, and some agencies are laying asleep, so you got to get out of the bed and you got to get in the truck, and then you realize, good God, this is a 45-minute drive to get all the way out there because they're at the very outer edge of my county. And so you get in the truck and you drive all the way out there, and while you're driving out there, your spouse is texting you because you forgot to let the dog out and the dog pooped and peed on the floor, and they're mad at you, right? Has this happened? Okay? And so you get there and you're still fighting with them over the text, and you just want to send that one last text telling them, I'm doing the best I can, I'm juggling all these balls, and I picked up the kids from soccer practice, and the family's sitting there looking at you thinking, man, they're playing on their iPhone when they show up, and they're supposed to be taking care of my loved one. And then you go back to the back of the truck and you're thinking, God, we need to get this bag, and I got to figure out how I'm going to get the stretcher up there because I got a really complicated, entryway into the driveway, and all the family sees is you're delaying. They're thinking, what? Rescue 911 says they get out of the truck and they run like hell and go save me or save my loved one. And so by the time you get in there, oftentimes they're unhappy already, right? I mean, they're already on edge, or they're irritated or unhappy. And, from their vantage point, just watching Rescue 911, they don't see all of those variables. All they see is it took you 50 plus minutes to get there, and they think your truck ought to be sitting at the edge of their driveway so that when you call them at 3, 4 in the morning, you're there in 30 seconds, because that's what they do on Rescue 911, right? So, we want to make sure that this is a reminder that when you are showing up at a scene, you are providing somewhat of a reflection of what they expect. Now, I realize you can't get out every call and run like heck to get into the house. That's not the way we do it. We got to check the scene to make sure it's safe. We got to figure out how to maneuver the ambulance. We got to figure out the bags, and we got to figure out those various things, but be mindful that that family is processing it totally differently than you guys did. And so there have been some major hospitals that have been struggling with these customer service issues and how do we reduce medical malpractice cases and the incident rates and things like that for us. And so Baylor is one of the hospitals systems that did some investigation, but there are a number of other facilities out there. And they have surveyed why patients ended up filing lawsuits against facilities. And you would think the number one reason would be because of money, and it really wasn't. The top number one reason, by percentage-wise, one of the greatest thing was the desire to prevent similar incidents from happening again. And then the second reason was a need for explanation as to why it happened. Then third was money, and then fourth was wanting to hold the provider accountable for their actions. And so some of these very large hospital systems have been scratching their heads over the last decade or so, trying to figure out, how do we fix this problem? If it's really not about money for the most part, at least initially, how do we try and address this? And so hospitals have tried some different things. One of the methods they've tried is what's called the hangout method. And that basically is when they have an adverse event, they pull in all of the team that provided care to that individual. And they sit them around a table and they bring in the family. And they say, family, this is not the standard of care that we intend to deliver. It's not what we aspire to be. Here's what we did when we were taking care of your loved one. We did this service, and this nurse right here did these following things, and this CNA did these following things, and this doctor did certain things, and this surgeon did certain things, all the way around the room, and they explain all of the details of what happened, satiating this need and desire to know what happened. And if they mess something up, they say, you know what, we messed something up. Here's what we messed up, and here's what we're going to do to keep it from happening to anybody else in the future. And when these systems have implemented these processes, many of them have virtually eliminated malpractice claims against them. Some of them like 90, 95+% elimination of malpractice claims against them. And so one of the things I encourage agency administration and directors and you guys to consider is, if we ever have an adverse event, we have some control over how do we respond and deal with it and try and avoid litigation. Do we circle the wagons and do everything protective, or do we do the opposite of that and embrace the family and try and work out a resolution and address some of their concerns? Because some agencies, very large hospitals, have had some really good success at avoiding these types of claims against them. And so all of that then fits in, because this is what ticks people off sometimes, is making sure that our professional actions match, that we're treating families with dignity and respect, that you are at your best when others are at their worst. And I realize I've taken care of a lot of patients. I know you guys have taken care of a lot of patients who cuss you out, who don't like you, spit on you, who do all these god-awful things, who are frequent flyers, who are the biggest pain in the neck. And yet you always have to treat them with respect and be at your best when they're at their worst. And try and match that urgency level whenever you can to fit their Rescue 911 perspective. And last of all, explain and inform. And a great example of that is, when they, on Rescue 911, they don't run codes on scene, right? They scoop them up, they put them in the truck, and they drive them there, and they save their life in the back of the ambulance on the way. Well, the family now, most codes aren't run that way, right? You guys run codes on scene typically. A lot of agencies do them on scene. Some still scoop and run. But some agencies will stay on scene, 30, 40, 45 minutes on scene, right? Well, if you're not communicating with the family, then the family is sitting there not understanding at all what is being done. And some of the research is pretty overwhelming that when practitioners explain to the families, here's what we're doing. We're going to do the following things of treatment protocol for this person. And I realize you think, we should be leaving, but we have a better chance of saving your loved one if we do this care here. And when you explain some of that stuff to them, they're more likely to say, wow, these people really care and they're making the right choices, and they're less likely to second guess and question. So just wrapping all of this up, the overall, the reminder is, always use your common sense. Call up the chain of command to the emergency department, to your supervisors, to DSS, to the police whenever you need to. Document what you do. If it's not documented, it's not done. Don't cover up. Tell the truth. Have great customer service. And then last but not least, consider having malpractice insurance just in case something weird and it all hits the fan. How do you protect you and yourself and your family? So, any questions that you guys have? The only last question, real quick, that I know we've had some discussion about is, particularly with Mission Health System, is, we've got this issue with Blue Cross Blue Shield, and what do we do with patients who say, I don't want to go to the nearest hospital, I want to go to the farthest hospital. How do we handle that? Or basically all the agencies confronting this problem and dealing with it. I know it's somewhat of a new problem because of the Blue Cross Blue Shield mess. I think, first of all, there's some stuff that's going to have to get worked out in all of this. A number of the agencies have pretty good forms that they have developed and are having patients sign of, the risks of going to a farther away hospital. That language is pretty good, although I want to tweak it a little bit, or I would give you some suggested content changes, a few words to broaden it. Some of the counties and agencies have also decided that if they already have a truck out of service, and then this patient is requesting to go to a farther away provider, to just simply tell the patient, look, our protocols and procedures won't allow us to do that. We have to take you to this closer facility because of our internal guidelines and procedures and things like that. I think that's reasonable, but I do think the county or your agencies really need to have this as a codified kind of policy and procedure of how they're going to handle this, and make sure that those documents are signed off on. I think when you do that, and if you do it properly, then I would foresee that would cut off any potential legal issues that I could really think of at this point. So thank you guys very much. I appreciate your time tonight. If there's anything I can ever do, please let me know. I appreciate the work you guys do and the sacrifice that you make for your family. So thank you.